Good afternoon. It is April 25th, 2024. It's 3:30 p.m. I would like to call the Diversion Board of Authority board meeting to order. Could I get a roll call, please?
Mayor Carlson.
Here.
Mayor Dardis.
Here.
Mayor Mahoney.
Here.
Mr. Peterson.
I am here.
Mr. Hendrickson.
Here.
Mr. Pipcorn.
Here.
Mr. Ebbinger.
Here.
Mr. Strand.
Here.
Mr. Campbell.
Here.
Mrs. Sherling. Mr. Grinberg.
Here.
Mr. Olson.
Here.
Mr. Seljevold. Quorum is present.
Thank you. Moving on to the approval of the minutes from the March 28th, 2024 meeting. Do I have a motion to approve the meeting minutes?
So moved. Second.
Motion and second. Any further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? That motion carries.
Madam Chair, I'd move the order of the agenda with the exception of moving the board chair update immediately after this motion approval.
Second.
Okay, so that would be a motion to approve the order of the agenda with moving the board update prior to the consent agenda.
Madam Chair, I have a question, if we could, as long as we're on the agenda topic. I had advanced an agenda item, and it was confirmed by the chair it would be on the agenda. Can you tell me where it is? Back, please.
I don't believe that I did confirm that, and it is going to be, the request that you made is part of the board chair update.
I have an email from our executive assistants that says the chair has added an item to discuss your request at the board meeting next week. So it was, to my knowledge, it was properly advanced. It was according to our policy, and to my knowledge, it was approved to be on the agenda. Why isn't it?
I did not approve that.
Okay. I move that we modify our agenda to include an action item which calls for a report on last Tuesday, April 9th. It's a detail, and I can hand copies up, but I move that we add that action item, which you had been sent, onto today's agenda.
We already have a motion and a second on the table, so this would be
Amendment.
an amendment to that motion.
And for the sake of the board, so they know what I'm talking about, you're not wondering, this is the action item I advanced to be on today's agenda. Agenda item requesting that the full Diversion Authority Board receive a detailed report and related documents from the Chair, Planning Committee, Directors, and Officers participating in Tuesday's meetings, April 9th, the basis and legal authority for such a subcommittee executive session, and discussions afterwards that ultimately led to or resulted in the resignation of our Executive Director, as well as policy clarifications showing where the chair actually was authorized to affect this personnel issue in such a manner and without direction of the full board. That's my addition I'd like us to vet and vote on.
Madam Chair, I'd call the question on the original motion, and Commissioner Strand, I would suggest could bring that up as a separate amendment to the agenda of the order.
Okay, so the matter has been called to question. There is a motion to approve the current order of agenda with the board chair update moved as part of that prior to the consent agenda. Could we get a roll call vote of that motion, please?
And to clarify, I can follow with an additional agenda modification motion? Yep, thank you.
Mayor Carlson.
Yes.
Mayor Dardis.
Yes.
Mayor Mahoney.
Yes.
Mr. Peterson.
Yes.
Mr. Hendrickson.
Yes.
Mr. Pipcorn.
Aye.
Mr. Ebbinger.
Aye.
Mr. Strand.
Yes.
Mr. Campbell.
Yes.
Ms. Sherling.
Yes.
Mr. Grinberg.
Aye.
Mr. Olson.
Yes.
And that is all.
Thank you. That motion carries.
Now, Madam Chair, I move to affect the agenda and modify it such that the action item I had presented last week is included in today's agenda. And I'll pass copies out to people.
There's been a motion made by Commissioner Strand. Is there a second?
Second.
Any further discussion? Seeing none on Commissioner Peterson.
Madam Chair, yeah, can we see what we're handing? We don't have
Absolutely.
context for this, so.
Passing it out.
Yep, I don't know what we're talking about.
And I'll continue. I really thought it would be on the agenda. for you to see proactively last week.
I just want to see what I'm voting on, Commish.
One comment I will make is that the majority of these items that you were requesting will be part of my board update. Mayor Mahoney.
So in essence, you're going to do, you're aware of his request, and you're in your chair's report will address those issues, so we really don't need the amendment, is what I'm understanding.
Correct.
Thank you.
And except that this would be at the direction of the board to receive these reports and to make sure that all of these details are covered, not just some of them.
Any further discussion? Are you all done reading it? All right, could I get a roll call vote on this amendment to the order of the agenda?
Mayor Carlson,
No.
Mayor Dardis,
No.
Mayor Mahoney,
No.
Mr. Peterson,
No.
Mr. Hendrickson,
No.
Mr. Pipcorn,
Aye.
Mr. Ebinger,
No.
Mr. Strand,
Yes.
Mr. Campbell,
No.
Mrs. Sherling,
No.
Mr. Grinberg,
No.
Mr. Olson.
No.
Thank you. That motion does not carry. So moving on to the board chair update. So first of all, there has been a lot of information and rumors that have been floating around, and so I wanted to take this opportunity to clarify what took place and state the facts. So in accordance with the Joint Powers Agreement and the Executive Director Employment Agreement, Article 6, the Executive Director serves as a report to the board chair. In that role as board chair, I was made aware of and additionally had my own increasing concerns related to the former executive director's inappropriate communications with a P3 developer, his leadership abilities, and his insufficient communication with board members. These warranted further examination. Separate from the planning committee, I met with the former director to discuss these concerns. I did not take, and I do not take this responsibility as a chair, nor the information that was presented to me or the information that I personally had lightly. Based on the course of our discussion regarding the concerns with his work performance, I chose to present the former executive director with a letter that sought to offer him a non-disciplinary, and I want to fully emphasize that it was a non-disciplinary paid administrative leave so that we were able to examine the concerns more closely. After being placed, after what I had hoped would be placing him on a non-disciplinary paid administrative leave, I intended to immediately call a special board meeting where the board would have had the opportunity to either affirm my decision, override my decision, or take a completely different action. And the former executive director was aware of that. It was also made clear to the former executive director that, again, this was a non-disciplinary action, and again, that the board could have taken a different position than mine. At no point was he asked to resign or forced to resign. In fact, I told him several times he did not have to resign. The former director ultimately did decide to resign after the discussion and gave a verbal resignation. As a result of his decision, I did call a special board meeting, and the board accepted his resignation in a 11-2 vote on April 11th, 2024. In addition to that vote, there was also a vote to allow legal counsel and myself as the chair to negotiate with the former director regarding compensation for his time that may be needed for ongoing litigation matters. Furthermore, considering all of the discussion related to epoxy-coated rebar and the dispute resolution board, I've asked Dorsey Whitney to review the Metro Flood Diversion Authority's contract related to our specifications within that contract related and regarding epoxy coated reinforcing steel, and to provide an overview of the dispute resolution board process and timeline. With that, if I could have Jocelyn from Dorsey Whitney come up. She has some information to share with the board.
Madam Chair, while she's coming up, do you mind if we have some comments or questions?
Why don't we wait until the full board update is completed?
Good afternoon. I'm Jocelyn Knoll. With me is my partner, Brian Kane. We are here to talk to you about the project, specifically the project agreement and how it relates to the current issue of epoxy-coated rebar coating. And then we'll go into the dispute resolution process as it applies under the project agreement. We'll be available to answer your questions and have any discussion that you would like that we consider to be not protected by the attorney-client privilege. One of the things I want to warn's probably a little strong. What I'd like us all to remember is we are in an open forum, and as a result, we've got to be careful about the attorney-client privilege because we are not in an executive session. So there may be times where I might table a question saying that's more appropriate to discuss in an executive session, so we maintain the attorney-client privilege. We all understand, and you folks have worked on this for years and have done, a lot of work. The whole objective here is always to act in the best interest of the project, and I know every single one of you has that and takes it to heart, as do we. I'd like to tell you a little bit before we jump in to the issue about Brian and myself. Both of us are partners in the law firm of Dorsey and Whitney. I've been practicing for 32 years. I've always been a construction lawyer, and more recently, my construction practice has taken me into the P3 space. I've tried to a jury and to a court 2 P3 projects, one up in Minot where I represented the city of Minot in a smaller P3 multi-use project where they were in litigation with a developer, and that was a successful result for the city. The second, I continue to represent the Regional Transportation District of Denver in its $2.3 billion Eagle P3 project, which is a commuter rail project. On that project, there was a $120 million claim brought by the concessionaire, also known as the developer. That matter went to trial, a bench trial, and the result was a complete defense verdict in favor of my client, the regional authority, the public authority, wiping out the $120 million claim. That matter was argued before the Colorado Court of Appeals last week, where the concessionaire is appealing the district court's decision, and we now await the decision of the Court of Appeals. So that's the background that I'll provide you with in terms of my own practice, and in addition, I handled the defense of the main target in the 35W bridge collapse over the Mississippi in Minneapolis. Brian?
Good afternoon. Again, Brian Kane from Dorsey. I've been with Dorsey and practicing for about 20 years now, and have been able to work very closely with Jocelyn on a wide variety of construction-related matters. So we're looking forward to having this opportunity to speak to you all.
Looking at, with regard to the project, and then more broadly, the epoxy-coated rebar issue, and that, as this board knows, there are other issues that could, eventually become larger claims. But I think it's always important to orient ourselves. The authority and the board are responsible for acting in the best interest of the project, always. Acting in the best interest of the project stakeholders, including the taxpayers, always. Enforcing the terms of the project agreement, acting in the best interest of the project, acting in the best interest of the stakeholders, means enforcing the project agreement. The project agreement, as this board knows, was negotiated and developed over a lengthy period. A lot of thought went into it. That is the agreement that drives the decisions, whether they're good for the board or not good for the board. It's that project agreement that we should always go to and look at for direction. And in terms of looking at the project agreement, and when we have disputes with the developer, we look to that project agreement for how do we resolve disputes with the developer. Again, the project agreement provides a very carefully thought out process for resolving disputes with the developer. This is not uncommon in projects of this size and magnitude. The most successful projects, and I consider the Eagle P3 project in Denver to be a successful project. The most successful large projects of this magnitude will have claims. That's the nature of large construction projects. And that's why a lot of thought goes into how do we resolve claims, and it's put right into the contract documents as it is here. There's a process here, and it doesn't mean we have to take it all the way to the mat, as Brian will explain to you in a few minutes, but to follow that process is essential. Turning now to the background of the epoxy-coated rebar issue. The authority, through its staff and consultants, brought the presence of the non-conforming work, the use of the non-epoxy-coated rebar, to the attention of the developer and asked the developer for its proposal to remedy the non-conformance. This is exactly how it's supposed to work under the project agreement. This is how it works on every large project. The authority to date has not received any proposal from the developer. Instead, the developer has submitted a written protest regarding the technical requirements. And excuse me, the technical requirements are part of the project agreement. The technical requirements have to be followed in order to have a successful project. The authority has in turn responded in writing. It's denied the written protest from the developer, and the dispute is likely going to be referred to the Dispute Resolution Board, which is the process the authority and this board bargained for in the project agreement. That's the process. The authority, through its project decision makers on the ground, has informed the developer that it's still willing to consider a proposal from the developer. And to date, there's been radio silence from the developer. Turning now to the relevant technical requirements section at issue here. It's up on the screen. It's got 3 sentences, 3 requirements, 3 separate requirements. First requirement is protect the exposed carbon steel surfaces with appropriate corrosion protective coatings or systems for areas subject to a corrosive environment, including de-icing salts. First requirement. Second independent requirement, provide epoxy-coated reinforcing steel for reinforced concrete. Third independent requirement, provide stainless steel or galvanized steel in exposed location. Those are the 3 requirements. They're independent, and they each stand on their own as a result. The current dispute timeline, there was a field visit by the project people for the authority on February 24th of this year. During that field visit, it was noticed for the first time that the developer was not using the required epoxy-coated rebar. A yellow light issue was issued from the authority on March 1. I'm not going to read every provision or every sentence on the slide, but you see what was said with respect to the yellow light letter. It's important to highlight that the authority said, please respond as soon as possible with your approach to resolving these nonconformances, because placing reinforced concrete is an ongoing construction activity. It is important this get resolved as soon as possible to avoid additional non-conforming work. That's what you want your people to say. And they did it. Current dispute timeline continuing. The next communication was on April 5th, earlier this month, and that was when the authority received the developer's written protest. In turn, under the project agreement, the authority was required to respond with a written decision on April 19th, which it did. The authority, having considered the project agreement, the technical requirements, the facts as uncovered, wrote back with its decision. And in short said, having considered the content of the developer's submission and having taken into consideration the relevant provisions of the agreement and the developer's submission, together with the facts and circumstances involved in the dispute, the authority concludes that the project agreement requires that epoxy-coated reinforcing steel must be used in all reinforced concrete for structures. Accordingly, the authority denies the developer's written protest. And I know this board is aware of this. For those in the audience that are not, epoxy-coated reinforcing steel for reinforced concrete in structures provides a higher standard of durability, performance, and service. There's been discussion and some debate both for and why the epoxy-coated rebar was required. We've talked to authority personnel, and we've looked at the documentation that's available to us in terms of the project documentation. Below is a summary of the points that were emphasized to us and which we gleaned from documents. And it's important that we look at the timeline of how this epoxy-coated rebar technical requirement came into play. And we know that there was long-term ownership and maintenance of the bridges and the railroad crossings had not yet been finalized during the procurement. We know that there was discussion with the North Dakota Department of Transportation, and that it was in the process of changing its standard specifications to increase the places for which epoxy-coated rebar was required. The county specifications generally followed the North Dakota Department of Transportation requirements. The United States Army Corps of Engineers, as you know, an important partner for this project as a whole, was questioning how the authority would ensure the longevity of the structures given the P3 public-private partnership delivery model. After considerable discussion, the decision was made to require all reinforcing steel for structures to be epoxy-coated. The requirement was included in draft 3 of the RFP, the request for proposal. Language was modified in draft 4 and remained unchanged thereafter. The epoxy-coated reinforcing steel for reinforced concrete in structures, again, the conclusion of the consultants and the members and the public entities that they went to, including the United States Corps of Engineers, concluded that epoxy-coated reinforcing steel for reinforced concrete in structures provides a higher standard of durability, performance, and service. Looking now at a couple of photographs that are part of the authority's record taken by its staff, you see a series of photographs here where we have some non-conforming work. This is concrete work, and then we see, in the far left, there's a picture of rebar. And this non-conforming concrete has to be patched, right? And we all live in an environment up here in the Northern Plains where we have a freeze-thaw cycle. So not only do we have water going into porous concrete, we also have ice. And then we have it thaws, it freezes, it thaws. And so the belief is that epoxy-coated rebar provides additional protection in that type of environment. You look at the next set of photos and you see more non-conforming work. You see rebar, and then you see that it will be patched. And again, the belief is the epoxy-coated rebar is essential to providing additional protection in this type of environment. There's been some debate about whether epoxy-coated rebar does what it's supposed to do. I'm going to tell you again, I've been practicing construction law for 32 years. There's always a debate in the engineering community on standards. You're always going to find somebody who can say, I wouldn't have done that. What this board, from a legal standpoint, needs to say is, what does the project agreement require? What do the technical requirements require? What somebody's own opinion is, whether they're on staff, whether they're in the community, whether they're a professor of engineering somewhere, doesn't matter. What was specified in the technical requirements? That's what is the driving force here. And you look at industry standards, and you see here in North Dakota that the DOT goes to epoxy-coated rebar. We looked, Minnesota DOT goes to epoxy-coated rebar. And so it's easy to play Monday morning quarterback, and where you will never go off the rails is if you enforce your contract. And whether or not that it actually gives, the coating and the performance that everybody hopes for, that's not the issue before this board at this time. The issue before this board is what was required in the contracts. And the issue before this board is, are you going to enforce your contract? And enforcing your contract is what is expected of you. When you start not enforcing your contract, you open a whole parade of horribles. This is a project that is going to continue under construction for a long time to come. We're not anywhere near to completion. So if you start ignoring provisions in this project agreement, it will come back to haunt you. Let's talk about some of the misinformation that has been out in the community on this issue. And again, I sincerely believe, and I know every member of this board does, that you are here to operate in the best interest of the project. Looking at the arguments and the statements that have been made in public forums, some of them are not correct. And some of them, unfortunately, can cause confusion with the issue and the dispute, and frankly, in the authority's position. As your lawyers, we want you to have a clear position, but we also don't want you to debate this issue in a public forum. You're all pulling for the same team. You all want the same thing. And the court of public opinion isn't going to resolve this issue. The dispute resolution process in the project agreement that you approved and that was signed on behalf of the authority, that will resolve the issues. Some of the examples of inaccurate statements: the authority is requiring all structures with non-epoxy coated rebar to be torn out. We've talked to staff. No, that's not their position, and that hasn't been their position. The requirement is a late change such that the authority has waived its rights relating to enforcing the requirement. It's not a late change. We went through the timeline with you. With regard to waiver of requirements, look, again, the project agreement contains specific provisions as to what constitutes a waiver, and this isn't one of them. Epoxy-coated rebar should not be required because others do not use it. Well, let's start with others do not use it. That's true. In some areas of the US and in some areas of Canada, they don't use epoxy-coated rebar. But here in North Dakota, Minnesota, the two states that will benefit the most from this project, they use epoxy-coated rebar. And our folks at the DOT, both in Minnesota and in North Dakota, as much as sometimes we scratch our head when we don't like the way they've designed a roadway that makes us wait a little bit longer, my experience has been with both DOTs. They work really hard on our behalf. And so if it's in their specifications, it's there for a reason. Again, we talked about how the authority is requiring all structures without epoxy-coated rebar to be torn out. And this provides you with why that is not factual in terms of the 4 points. Again, I'm not going to sit here and read through these points with you, but as I summarized earlier, that's simply not true. Again, the requirement is a late change for which the authority has waived its right, and this takes us through the specific timeline. And it wasn't a late change, and the authority has not waived its rights. Epoxy-coated rebar should not be required because others don't require or use it. Again, we take you through some of the more relevant facts, but what I do want to draw everyone's attention to is the 4th bullet point here. Epoxy-coated rebar lengthens the expected life of the structures. In the developer's own written submission, the developer, the quote here comes from the developer, "This protection helps to prolong the service life of the reinforced structures whilst reducing maintenance costs over time," close quote. That's an admission from the developer.
Eric, are you hearing it?
Allowing black rebar would reduce the value the authority and its taxpayers, its stakeholders, are to receive from the developer for the agreed price. The developer priced up this project. The developer spent a lot of time poring over the contract documents, the project agreement, the technical requirements. They priced this project, and we have to assume they priced this project for epoxy-coated rebar. It's the benefit of the bargain. What is the authority and what are its stakeholders entitled to? The benefit of the bargain. And the benefit of the bargain included the price to procure and install epoxy-coated rebar. Looking at the summary of the issue, the written decision that was issued by the authority, and I will let you know that Brian and I approved that written decision from the authority. The authority wrote, as you are aware, the authority, as a matter of good faith and in an attempt to mitigate damages caused by this omission, has previously indicated that it would respond expeditiously to any reasonable approach the developer may propose with respect to resolving the resulting nonconformances. The authority remains ready and willing to consider any such reasonable proposals. The developer has made no attempt to remedy a clear nonconformance with the requirement to provide epoxy-coated to steel reinforcing for reinforced concrete and structures. Instead, the developer continues to submit design submittals without epoxy coating of steel reinforcing for reinforced concrete for structures, and continues to place significant quantities of concrete around reinforcing steel that is not epoxy coated in structures. The developer does this at its own risk. This is not an uncommon position from a public authority when a contractor is not following the technical requirements. We're going to talk briefly now about the dispute resolution process in the project agreement.
Thank you. So as Jocelyn has indicated, the epoxy-coated rebar issue is at the very front end of what is the first step of the dispute resolution process. And if we go to the next slide, the project agreement provides a series of activities as required in order to address disputes. And the first step of the dispute resolution process is the written protest process, in which the authority is currently involved relating to the epoxy-coated rebar issue. That if the dispute is not resolved through the written protest process, then there's a process in which the dispute may be submitted to the dispute resolution board established under the project agreement. And then if the dispute remains after a recommendation of the dispute resolution board, then there are procedures relating to further mediation of the dispute, and ultimately, if mediation were not to lead to a resolution, to litigation. But again, we're at the very first step of this process. With respect to the written protest process, on the next slide, as we've said, the developer has submitted its dispute via a written protest to the authority. Last Friday, within the 10 business day requirement, the authority submitted its written decision denying that written protest. The developer now has an opportunity within 7 business days of that response from the authority to submit a written rebuttal, if it so chooses to do that. That deadline for the written rebuttal is coming up on Tuesday. And if that is submitted, then the authority must issue a final written decision within 7 business days of receipt of that rebuttal. Upon issuance of the authority's written decision, then the developer would have 10 business days to indicate whether whether it continues to object to that decision. If it does not accept the authority's decision within that time frame, then the developer has the opportunity to submit the dispute to the dispute review board. And under the project agreement, we have 2 separate dispute review boards that have been established. One, a financial dispute review board, the other, a technical dispute review board. Depending on the nature of a matter in dispute, the matter would be referred to the financial dispute review board or the technical dispute review board. Those members that comprise those 2 boards have been selected, and there is a meeting of the review boards scheduled for tomorrow, a preliminary meeting not specific to any dispute at
Or
all.
like a kickoff meeting.
Yeah, exactly. If this matter were to proceed to the dispute review board, again, it's the developer presumably would submit it within the time frame required following the authority's final written decision with respect to the written protest. And then there are certain time periods set forth relating to the dispute review board work. And it's anticipated that a hearing before that board would occur within 20 days of a party referring a dispute to the board, unless the parties were to agree to a longer time period. Ultimately, after a hearing, after the parties have presented their evidence to the review board, it is then the dispute review board's obligation to provide a recommendation within 10 business days upon completion of the hearings. And again, if a party is not or does not accept the recommendation of the dispute review board, that party has an opportunity to reject it or to object to it. And if a party does object or reject the decision of the dispute review board, then the next step in the process is mediation. And there are specific timeframes set forth in the agreement for the parties to mediate before a private mediator. And then ultimately, again, if the dispute were not resolved through that mediation process, the final step would be a litigation process. Obviously, that is far down the road from where the developer and the authority currently are with respect to the epoxy-coated rebar issue. So that summarizes the dispute resolution process that is specified in detail in the project agreements.
It's important to note here, and you'll see that bullet point on the slide in front of you or on the screen, the fourth bullet point. While a dispute is in play, the work has to continue. And so during dispute provision or proceedings, the developer will continue the work, including any work subject that is the subject of the dispute, using reasonable efforts and without delay. This is a common provision in most sophisticated construction contracts, and it's there to make sure that a dispute cannot be used as a reason to hold up the project. Obviously, the responsibility for the authority is to make sure that it continues to make any payments that might be due of undisputed amounts. Again, a very common provision in a complex construction contract. This brings us to the end of our presentation. We have the materials, which is the relevant technical requirement section specification. We have copies of that. We have copies of the yellow light letter. We have copies of the written protest letter by the Alliance, the developer, and we have the copies of the authority's written decision available for handout. Are there any questions?
Thank you, Jocelyn and Brian.
Thanks.
Are there any questions for the Dorsey legal staff? Commissioner Peppercorn.
Thank you, Madam Chair. So I have a question. So is it common for the executive director and the developer to have contact, obviously emails or phone on a daily basis, or from your experience?
It isn't uncommon in certain situations. More commonly, it's the project staff or the public authority that is in those conversations. It's, it's making sure from a leadership standpoint that the right person and the person that's been put in that staffing position is carrying out their responsibilities. So it's different management styles, obviously, but the more successful projects, large projects, including P3 projects, you there's a lot of delegation that goes on. The executive director on a large project, again, I'll bring into, as an example, the Eagle P3 project in Denver, that executive director during that project had a lot of things on his plate. And as a result, he leaned on his staff and his consultants.
Great, thank you very much. I have one more question, and actually, Ms. Williams from the Corps is here, and so I'm very thankful for that. My question is, did the Corps in our very same diversion use epoxy-coated urea in the, I guess, the control gates and all that? I guess that's my question for her. If you don't mind just stepping up to the podium and you can just answer that real quick.
Commissioner Pepcorn, board members, glad to be here this afternoon. I can talk about what we require in our Southern Embankment features. So as you know, we built the I-29 raise project, but that was designed to DOT standards. So definitely epoxy coated rebar in the bridges that cross the borrow ditch per DOT standards. The design of that project was absolutely worked through with the appropriate DOT folks.
So can I just jump in? So would you say that like the road decks are what you use epoxy coated urea for, but actually the construction of the bridges, but not the rest of the project? Would you say that's correct?
I would say so for the three large structures, the diversion inlet structure, the wild rice structure, and the Red River structure, it is used in the bridge components of those three structures that
Right.
span each one of those.
Right. So thank you, Madam Chair. That's critical. So what you use epoxy coated rebar for, and I'm not the expert, they are, you use it when you're exposed to salt, bridge decks and roads. You don't use it for all the other stuff. And so that's the common sense answer. Once again, I'm no expert, but that's what should be going on. What they're talking about is using epoxy coated urea for everything. And Chad, you're in construction. You don't use epoxy coated rebar for everything. So thank you, Madam Chair. That's the end of my questions.
Jocelyn, could you maybe go back to the slide that talks about, regardless of others' opinions in regards to if something should or should not be in a contract, once it's in the contract, that's what our stance is, and we expect that the developer will follow through with what is written in the contract.
Sure. It's important, with respect to, you can look at, I'm going to start off with, you can look at any project and what were in the specifications for that project and the technical requirements. With respect to the Army Corps pieces of the greater project, I'm sure my colleague would say, the technical requirements or the equivalent of, that's what guided their decisions and their choices of what they used. And that's the same with any project. And here, there was the requirement in the technical requirements. It's a contract specification. It's a part of the project agreement, and it required epoxy-coated rebar. So I understand and I respect your position on it. The reality is, from a legal standpoint, from a contractual standpoint, what was required in the project agreement. And that's what governs here.
Thank you. Any further questions or comments? Commissioner Strand.
Thank you, Madam Chair. And I'm not sure where you're going with your chair report next or not, but this topic has been before our board and it's been in executive sessions, and now there's information that's public. So this is now the community knows what we've been discussing. Help me understand, however, how this issue led to us not having an executive director anymore.
Commissioner Strand, I know enough after 32 years of practicing law to stay in my lane. And that's beyond the scope.
I appreciate that. So I'm asking the chair if this will be following this discussion or when we will discuss that topic so we have an understanding what took place, because we don't. And we deserve that.
So Commissioner Strand, what I can say is what I said prior in my statement, that I had increasing concerns related to inappropriate communications of our former executive director with the developer. We have a fiduciary responsibility as the Metro Flood Diversion Authority Board to enforce our project agreement. And when we have an executive director who is arguing against our project agreement and suggesting the acceptance of non-compliance of a P3 developer, I had extreme concerns related to the communications, and I wanted to ensure that our project was not going to be in jeopardy.
Madam Chair, that's why
Commissioner Pepcorn.
this should have gone to all of us sitting here.
As I stated, I had the authority to put the former executive director on non-disciplinary, paid administrative leave while those concerns were examined, and I had intended to call a special board meeting where you could have either affirmed or overrode my decision or done something completely different.
So,
I
Madam,
was concerned about the project, and as the chair, it is my ultimate fiduciary responsibility to ensure that there were not inappropriate communications that were being held with the developer related to our contract.
so Madam Chair, once again, this should have gone through the entire Diversion Authority board without question. And so what I'm going to request is that we have an executive session with Joel Paulson, without Martin Nicholson and John Shockley in the room, and to have it recorded like it's a regular executive session. Whenever we can arrange that, that's my request, because I think the truth needs to be heard by everybody on the board, not just 6 of them. And there's also been statements by some of the people on this board very derogatory towards the Joel. And I want everyone to hear those. And I want you to have to answer for the statements that were made, that he was a thief, things like that, that he was stealing, that the staff couldn't work with him. I think that all needs to be answered, and that's what I was told. And so that's my request. We need to have an executive session with Joel. Thank you, Madam Chair.
So Commissioner Pepcorn, I do not believe that we can require somebody who's no longer on staff to participate in the meeting. Any further questions or comments? Commissioner Strand.
Madam Chair, I'm going to remind our board, and my issues are board related, boardsmanship, policies and procedures for a board. We all have our flow chart of the chain of command. We have a board of directors. We have an executive director. And below the executive director, you have all these committees and all these other people. Now, we have one single point of contact. That's our executive director. That's the only person that we have any authority over. And you say, Madam Chair, that it's your authority to hire and fire. As I read our Metro Flood Diversion Authority powers, executive director, to hire and terminate an executive director, that's an authority of the board. It's the board's responsibility to hire and fire an executive director, our only single point of contact. It's not anybody else's authority. Now, the right thing would have been convene the board and tell us what your concerns are, and the right thing would have been go down the paths of properly, professionally handling an HR issue. Who consulted us on this HR issue? I can tell you, I've gotten legal advice from our legal counsel. I can tell you I've gotten significant guidance from our director of HR. It's absent in this process. And we're the board. So we should expect a professional level of delivery of services to our only point of contact employee, our executive director. Obviously, there's a difference of opinion on technical issues and on litigation and approaches to court situations. But we still have our roles and we have our responsibilities. It's our responsibility to hire and fire a director, an executive director. It's nobody else's. So my contention is you should have convened the board to bring us all up to speed on the information We still don't know.
Madam Chair.
Commissioner Campbell.
Commissioner Strand and board members, you know, we talked about several things that have come up over time, and we've had to go into executive session to talk to some of the things that Jocelyn has talked about here. And ultimately, the direction that was given is that when it comes to the contracts that have been established, that's been talked about, that the only people we wanted negotiating those contracts were our attorneys. Those were clear. That we all as a board agreed to that. And if you don't, then we can take a poll on that if you want, because that's certainly my understanding, and it was a direction that we gave, that the only person that we wanted negotiating these contracts was the Onstead Twitchell and the Dorsey law firms on our behalf. In defense of our board chair, something came up that made her have concern that somebody other than those two were trying to negotiate this contract. And so the process that she took, it's my understanding the process she took, was something that she needed to make sure of that was not interfering with our direction. And you ask about calling for a meeting. How much time would we want to have for potentially more things? What could somebody else possibly have done to damage our position without having the proper legal counsel involved? That's why we said legal members only are to deal with this. That was the direction of this full board. And you know, to put this onto anything else, all that Chair Carlson was trying to do here was to make sure that would not happen would be something that would take a position other than what we directed and what we have as a contract.
Commissioner Ebinger.
I will agree with Commissioner Strand on the fact that it is this entire board's responsibility to hire and to fire the executive director. I would offer to you, sir, that didn't happen. No one was hired. No one was fired. We had an employee who resigned when he was told that there was going to be some scrutiny given to his conduct. You, myself, Commissioner Campbell, and the rest of us were all in a room in the executive session when we agreed that the only contact on negotiating the epoxy-coated rebar issue with the developer would be Onstead Twitchell and Dorsey. We all shook our heads. We all left the room knowing that, including our former executive director. I am understanding that this is concerning. And I'm understanding that a lot of people are angry at our lawyer right now. But a lawyer's like an oncologist. The information they give you is not something you want to hear, and what they have to do to address the issue is not something you want. And none of us are happy about what happened here. But that doesn't mean it isn't the right thing to proceed. And I appreciate the position that Mayor Carlson's been put in, but we will not vilify her for doing due diligence in meeting the requirements of this board to make sure that the diversion is built, it is built to last, and it is built within the budget. Thank you.
Mayor Mahoney.
As long as we're clearing up rumors, there were not 6 people that knew of this resignation. We met as the Planning Commission. 6 members were present at that, talked about the attorneys would continue to litigate their issues that we're talking about or were in charge of whatever was going forward. Only 2 people were in the room with the discussion with Joe Paulson, which is our chair, Mayor Carlson, and Kevin Campbell was present at the time. First time I heard of Joel's resignation was an email went out by council, and that's how I found about it, as much as every one of the board members here. Second item, an employment contract. This board approved that when we hired Joel, the chair was put in the position of working with the CEO. The chair was put in the position that they did have disciplinary items that they could do, and this was a non-disciplinary leave of absence. But the chair had that position in power and has to go to the board once any of those decisions were made, which was done. A session was called immediately after that, and the board voted 11-2 to accept the resignation. You may not like it. You may not feel that that's what you want to have turn out. Joel Paulson did great work for us. Mr. Pepcorn, don't disagree at all. And I'm sorry if there's rumors out there. He's got this project going. We're moving forward. It's headed at a great speed. It's a lot of places we're ahead of schedule. But we have to keep in with our cost confines we have. We have to keep to our schedule. And our contract is really what we're arguing. It's our contract is what we're arguing right now. And if people don't respect our contract, then they have to be brought to bear. We have legal ramifications for that, which the board now, in my mind, has met 3 times and affirmed over and over and over. We will follow the legal's lead on this, and we were all told to stand down. We were all told, if we had a better way of doing it, we were all told to stand down, which we are. So I think, Chair, it's about time for us to continue with this meeting. We have a lot of work to do. Unless there's another element or something else, Commissioner Strand, you want to suggest, then I would suggest we continue to move forward with the agenda.
Commissioner Campbell.
I just want to clarify one thing that Commissioner Ebinger had brought up, and that, you know, there seems to be this focus that this is about epoxy-coated rebar. That's not what happened with the executive director issue. The issue was there concern over the direction that was given, that nobody talk about this except our attorneys. There are several other things that are going on in this process besides epoxy-coated rebar that we have serious concerns about, and we talk significantly about them, along with maintaining, being sure that we stay on the timeline to completion. And so it was with all those discussions that the direction was given, the appropriate direction was given, in my opinion, on what should be done, and we all agreed on that. And if the chair felt that through this process somebody wasn't following that direction, she had every right to do what she did.
Madam Chair.
Commissioner Grinberg.
I'd move the consent agenda to move the meeting forward.
Madam Chair, we're not done with this topic yet.
Madam Chair.
Commissioner Grinberg.
Second.
Okay, we have a motion to approve the consent agenda and a second to approve the consent agenda.
That's embarrassing.
We are going to move on, Commissioner Strand.
Madam Chair.
Call question.
How embarrassing.
There's no such thing as calling for a question.
There isn't a motion.
There isn't a motion, yes.
Just been moved
If
and
you guys
seconded.
want to squelch the voice, go right ahead.
There's a motion and a second for the consent agenda. Any discussion on any of the consent agenda items? Hearing none. All those in favor of this roll call vote, sorry. Roll call, please.
Mayor Carlson.
Yes.
Mayor Dardis.
Yes?
Mayor Mahoney.
Yes.
Mr. Peterson.
Yes.
Mr. Hendrickson. Yes.
Has he? Sorry.
Mr. Hendrickson?
Yes.
Okay, thank you.
That's 3 yeses.
Mr. Pipgord.
No.
Mr. Ebinger.
Yes.
Mr. Strand.
Yes.
Mr. Campbell.
Yes.
Mrs. Sherling.
Yes.
Mr. Grimberg.
Aye.
Mr. Olson.
Yes.
Motion passes.
Thank you. Moving on to the co-executive director report, I will turn this portion of the agenda over to Robert.
Madam Chair, members of the board, good afternoon. Robert Wilson, County Administrator, Cass County, and in this role, co-executive director, along with my colleague, Mr. Mike Redlinger, City of Fargo Administrator. My report at this point will be very brief and just say that it is our goal, and we will absolutely fulfill a responsibility at this point to serve the board, serve the employees of the Diversion Authority and do everything within our power to make sure that this project continues to move along unimpeded, and we will do everything we can to further that goal. And that concludes my report.
Thank you, Robert. Any questions or comments of Mr. Wilson?
I would like to ask Mr. Wilson, what was your role in the exiting of our executive director? You were in the room.
Madam Chair, Commissioner Strand, I was asked to attend a number of meetings on the day of the Planning Committee, and I attended those meetings as I was requested to attend.
Other questions for Mr. Wilson?
Commissioner Strand, don't put this on staff. Robert was expected to be there. He's staff. This is nothing that we start going after staff.
Right. Thank you, Mr. Wilson. Commissioner Ebinger.
I just want to express my gratitude to have both Mr. Redlinger and Mr. Wilson, that we have their competent leadership here to fall back on.
Thank you. We do not have a general counsel update this month for the Metro Flood Diversion Authority, so we will move on to construction project updates, and I'll turn this over to 7A to Ms. Terry Williams.
Good afternoon, Chair Carlson and board members. I'm Terry Williams with the Corps of Engineers, and I'm happy to present our update for the month of April. For number 1 and 2, we've talked before about the diversion inlet structure in the wild rice. We've had an issue with the gate machinery. We have, through vigorous analysis, we are actively working with our contractors to make some changes to the design of that machinery and the components. And I will be able to give you a lot more detail on the timing of the completion of those changes, probably in another month. As I said at the last board meeting, we believe all of the changes and fixes should be in place by summer, fall, and commissioning and training for the diversion inlet and the wild rice will commence about then. The I-29 raise construction, nothing new to report there, except that we are actively working on the O&M documents for that phase. Number 4, the Red River structure, the drone footage covers this again this month. We're at 56% complete, and our construction completion date remains 19 March of 26. Number 5, during 27 wetland mitigation, the seeding is about complete, and then it will enter the wetland establishment period that goes on for about 4 years. Drayton Dam, still planning to have that event this fall, and the plantings, the willow plantings, might be going on right now as we speak. Number 7, SE2A, the contractors remobilizing and construction should be starting up again for the season. Moving on to number 8, our FY24 contract awards. The only real news here today is that the forest mitigation contract was awarded last night. $4.4 million, and it went to DJM Ecological Services, a firm out of Missouri. We had 3 bids, and they ranged from $4 to $4.4 million. Number 9, our remaining design elements, 3 and 5, are on schedule for awards in January. One thing I skipped over, back to more news on our contract awards. We did advertise Reach SE4 for bids, and those bids are currently due on the 5th of May. That will be a 4 to 5 mile reach, our first long reach of southern embankment construction in Minnesota. Number 10, the supplemental environmental assessment. We're putting the final touches on that document so that we can publish it again to the public. With that, Chair Carlson, I can stand for any questions.
Any questions for Ms. Williams? Seeing none, thank you very much.
Thank you.
I will turn over the next portion of the agenda to the MFDA engineer, Chris Backyard.
Thanks, Chair Carlson. Board members, a quick update today. You can see on the map, we're making nice progress. Most of the channel now is in our tan color, which means we're in progress. there's just a couple of segments of channel that are yet to be started, but things are moving along nicely. We did start officially in Channel Reach 13 this last month. That's the reach that surrounds the Cheyenne River. So the contractor is moving in and doing work in those areas. They have, of note, in upcoming, they are mobilizing equipment now and planning to start driving piling for the Cheyenne Aqueduct within the next month. I anticipate that to start. If you've driven west out of town, you'll notice they do have some traffic control set up. They are working to establish the bypasses for the I-94 project. That's scheduled to be operational by late summer. And then they'll start working on the bridge structures on I-94 as well. Real quick update, we've reached over 2,600 design submittals and submittals that we've reviewed on behalf of the developer. So our design teams and our review teams are continuing to work hard to get the finish, to complete the plans. And I think that's probably the main highlights for the channel construction. I can stand for any questions related to that before I give the safety update.
Any questions for Mr. Buckigard?
Madam Chair, so can I ask you, what's like a ballpark percentage of how completed are we overall?
Overall, and I take overall, Commissioner Pepcorn, like looking at the city work, the core work, the channel work, we're between 25 and 30% overall. So in my tracking, we're right on track on as far as our overall schedule goes.
Thank you.
Any further questions for Mr. Buckigard on this issue or this agenda item? Right? We can move on.
Yeah, real quick safety update. Again, a good progress month. We had 2 minor incidents this month. Both were related to individual issues. One worker slipped getting out of their equipment and hurt themselves a little bit, a minor injury, and one had came in contact with a piece of the forms and hurt their ankle a little bit. So some minor injuries. So good news where safety is working very well on their safety program. Just note we are nearing 1 million hours worked on the channel project. So that's a nice milestone of the hours that our team has been putting in to get our project built as well. So with that, I can stand for any questions on the safety update.
Any questions related to the safety update? Seeing none, you can move on to the drone footage video.
I'm Tom Fuchs, Senior Construction Manager for the Metro Flood Diversion Authority, with some news on big deliveries for the FM Area Diversion Project. Parts of the first of 3 massive radial arm gates for the Red River structure recently began arriving at the construction site south of Fargo-Moorhead. In the coming months, 27 shipments are expected to make the 1,200-mile trek from Russellville, Alabama. Once here, crews will begin gate assembly on site. Each of the Tainer gates will weigh nearly 300,000 pounds, or about as much as the Statue of Liberty. The gates will be mounted in the structure's bays and will close during diversion operations to hold back floodwater from the Red River until it can be released through the stormwater diversion channel. And that's not all. The Corps of Engineers contractor has been continuing its concrete work with more than 2,000 cubic yards placed in April at various features of the structure. There's lots of concrete being poured over at the Maple River Aqueduct as well. ASN Constructors has now completed the last segment of the flume and conduit structure's base. Crews have also completed several of the structure's piers and have now started concrete work at the adjacent wing wall footings. As our drone view takes us from west to east, we can see the completed piers outlining the structure's flume, where the Maple River will pass over the stormwater diversion channel. With winter in our rearview mirror, ASN Constructors has shifted from not just digging the 30-mile-long stormwater diversion channel, but to also building the levees that line it. They've moved another 500,000 cubic yards of dirt in the past month in reaches 5 through 9, and they began constructing the levee in Reach 13, which is near Horace, North Dakota. ASN is also working on a number of the channel crossings. The crossing at County Road 32 became the first of the 19 crossings to start bridge deck formwork. At the I-29 crossing north of the metro area, crews started driving H-piles. To the southwest, motorists have begun to see lane closures on I-94 as ASN begins building temporary bypasses to make way for the future bridges that will span the channel. You can stay caught up to date on any construction that may impact your commute on our website, fmdiversion.gov.
All right, moving on to number 8 on the agenda is our communications team update, and I'll turn this over to Amy.
Good afternoon, Madam Chair and members of the board. Excuse me. This past month, the communications team had the opportunity to help with some outreach and education in the community. There was a presentation given for the UND School of Engineering. Chris Bockegaard had the chance to present as well to the Western Association of State Highway Transportation Officials during their annual meeting, and he also facilitated a tour so they could see more of what was taking place on the project. He also was able to give a tour to UND Civil Engineering and Water Resources students, which is the picture that you see there. And then Chris, as well as Kevin Dunn with the Corps of Engineers, presented to FEMA Region 5 earlier this week at their State Partners Conference. Beyond that, I just listed some of the pieces that we developed last year for education and outreach that were actually recently awarded through the North Dakota Professional Communicators. And so that list is on the screen for your awareness. And that's all I have this month. If there's any questions, I'm happy to answer.
Thank you, Amy. Are there any questions for Amy? See none, thank you. Moving on to land management update, and I believe that Jody Smith is online. Yep, I see her, so I will turn this over to you, Jody, for the property acquisition status report.
Jody's been asking me to fill in. Unless she chimes in quickly, I'll fill in for her. Good afternoon, Board. Eric Dodds. Jody's actively working on some mediation today, trying to resolve some of our ongoing disputes with the property acquisition team, so she's asked me to fill in. As you see in your packet, the property acquisition status report, you're all probably very familiar with this. As just a brief reminder, the green color is good. That means we've acquired all the rights we need on those properties. Blue means we're continuing to be in negotiation. The orange colors are parcels that are in an eminent domain status. We are actively continuing to negotiate on those as well. The next page is overall progress pie charts. On the left side, the construction footprint's 95.4% complete. That's a 0.5% increase from last month. On the right-hand side is the UMA footprint. You'll notice this is down about 5% from last month. That doesn't mean we went back in time. It means that we're simply counting the parcels that are now affected by Christine and Wolverton. Previously, those were excluded from the math. They are now included as we're actively working on those acquisitions. The next page drills into those a little bit more detail. I would just note on the stormwater diversion channel, we have reached agreement on all of those parcels, just working on closings, and the same thing for the Oxbow Hicks and Bakke project. Similar numbers on the landowner overview. This page here shows you whether you want to look at the numbers in terms of parcels or if you want to look at it in terms of owner groups. You can see lots of numbers on this page showing you the progress. Then the last page goes into some key activities. The first bullet point we always like to remind folks is even if we have filed eminent domain, we are continuing to negotiate where there's willingness on the other side. Again, Jody's in mediation today and has been busy with that the last few weeks. We did complete 4 necessity hearings in Minnesota. That resulted in obtaining property rights on 29 parcels for Southern Embankment Reach 4 and Reach 5. In the last month, we also closed on 12 parcels, 8 of those in Minnesota, 4 in North Dakota. After those necessity hearings were complete, we were able to certify the right-of-way to the Corps for Southern Embankment Reach 4 and Reach 5. Regarding Christine, we have obtained rights of entries on about 57% of those property owners. That was voluntarily obtained. We are now working on obtaining the remainder of those rights of entries via court process. We have started the acquisition in Wolverton. We have a landowner meeting with those residents on May 7th, working closely with the Buffalo Red Watershed Group. We are working on platting the lands for the diversion channel. We've completed 3 of the plats by township, starting on the north end with Weiser several months ago, and in the last month completed the Harwood and Berlin township plats. And as farming activities have ramped up here this spring, we've completed staking of all the farmable areas adjacent to the southern embankment and Oxbow, so the farmers know where the project limits will be. And Madeline's been busy on farmland leases for this year as well. So with that, stand for any questions.
Thank you, Eric. Any questions? Seeing none, you can move on to the OINs.
Sure. The next item in the packet is related to excess land. So there are 7 parcels of excess land that are in your packet today. These have been suggested to be broken down into 2 different groups for action. These groupings of excess land have been recommended by the executive director, and then moving through the process, we had a land committee meeting on Tuesday where the land committee approved these recommendations, and the Cass County Joint Board approved these this morning as well. The first 2 parcels, 717Y and 9732Y, are on the west side of the diversion channel. In that situation, the property owner had asked us to buy the full square, and now we have some small remnants remaining, just under 8 acres. The proposed sale price of this is $76,000 based on the price that we paid for those parcels. Unless there's any questions, I'll keep moving forward. The next 3 parcels are all related to the rail corridor in Horace. These rail corridors, as you may recall, going through the disposal process, there's a statutory process where the railroad had to follow, and now we have ownership of portions of that rail corridor, and so we're moving through the next steps here. This first piece, I don't have all the stats memorized yet, so bear with me. There you go. Thank you. Recommended sale price here is $53,000 and change. These are based on 50 cents a square foot, which I understand is about the lowest price that we had paid for that land. This parcel is just under 2.5 acres, and we would be moving forward with recommending this following the process that the board had approved. The next piece is ON 7248. This is another piece of the railroad. Again, recommended sale price is $22,433, again, based on that $50 cents per square foot. Scroll down to the map, you can see where that parcel is located, just further west. And then the following piece of the railroad is a little bit further west. Recommended sale price here is $84,942. So just a little bit further west of the first 2 that we looked at. In all of these situations, again, we'll follow the policy that the board had approved, going to the member entities first, giving them a minimum of 30 days to respond, and then going to the adjacent landowners, asking them for interest. We do understand Jody's had a number of phone calls from these adjacent landowners expressing interest, so we do expect we have a willing buyer.
Move to approve.
Second.
That would be to move to approve all
A and
of them.
B.
A and B. Okay. And a second, Commissioner Peterson.
Madam Chair, thank you. Mr. Dodds, a lot of these are adjacent smaller home lots, so I'm just clarifying, are we approaching those folks too? So I know they have the potential for the developers, like last one example, a large lot adjacent, but are we approaching the homeowners as well or not?
So these will be sold as one chunk, but yes, the adjacent landowners will all receive notification. It's our understanding that the neighborhood has been sort of communicating amongst themselves, and they intend to submit kind of a group package to buy this chunk of land.
Okay, outstanding. Thank you.
Yep.
Commissioner Campbell.
Madam Chair, thank you. In the Lands Committee meeting, I think the reason that this was broken down into 2 separate groups was, I think 2 of the parcels required flowage easements.
Yeah, the remaining 2 parcels that are in your packet here are in the upstream mitigation area, and they were separated because we do need to reserve a flowage easement on those, and so the motion language is just a little bit clearer. These are both former rural residential parcels that have been acquired. All of the structures have been removed. We do need to reserve some of the trees on these parcels as part of a mitigation effort for other environmental mitigation. So there's a recommended sale price of $5,000 per acre on these two parcels in the upstream mitigation area.
I guess I just wanted to be sure that the motion were to include those necessities regarding the flowage easements on those parcels.
I'll accept that.
Okay. So that amendment to the motion has.
Yeah, I think there's there's a recommended motion in your packet, I believe. So, yeah.
Okay, there's been a motion and a second with the friendly amendment. Any further questions? Seeing none, this is a roll call vote. So could I get a roll call vote, please?
Mayor Carlson?
Yes.
Mayor Dardis?
Yes.
Mayor Mahoney?
Yes.
Mr. Peterson?
Yes.
Mr. Hendrickson?
Aye.
Mr. Pipthorn?
Aye.
Mr. Ebbinger?
Aye.
Mr. Strand?
Yes.
Mr. Campbell?
Yes.
Mrs. Sherling?
Yes.
Mr. Grimberg?
Aye.
Mr. Olson?
Yes.
Motion passes.
Thank you. Moving on to number 10. This is a finance update, and I'll turn over to Mayor Dardis.
Thank you, Madam Chairman. The Finance Committee met yesterday, April 24th. There were bills submitted for effective as of April 17th for $7,166,699. Also, our finance report was given as our net cash position is $245,061,927, and we also had some land acquisition directives that took place that were passed. One was for in-town levies for $40,000. There was a Minnesota issue with regard to forestry for 29 acres. That was $300,000. And the one within Minnesota, there was also an item for $2,681,500. That concludes my report. If there's any questions, I'd be happy to answer them.
Thank you, Mayor Dardis. Any questions for Mayor Dardis? Right, seeing none. Do we have any other business? Mayor Dardis.
Madam Chairman, we've had an interesting meeting and an interesting couple of weeks. I've been involved in the diversion and getting this thing built for just about 15 years. And 5 years on this committee and on this board. And I couldn't be prouder to serve with the men and women that are on this board. We have had unbelievable leadership rotate from Clay County to Cass County to the two cities of Moorhead and Fargo. That leadership has been unwavering. My next door neighbor was Darrell Vaniel way back when. He was a tough one, and he helped us get to where we are today. The actions by our chairman recently were so appropriate, so warranted, and followed absolute protocols. I couldn't be prouder to call Mayor Carlson my friend and the chairman of this committee. There's been a lot of innuendos and rumors out there. I hope that a lot of that was set straight today. There was nobody terminated. There was nobody fired. A non-disciplinary action was presented. The results were totally at the direction of that individual. So on behalf of myself, Mayor Carlson, thank you. Thank you for your leadership.
Thank you, Mayor Dardis. Any other business?
Move to adjourn.
Motion to adjourn in a second. All those in favor signify by saying aye.
Aye.
Any opposed? We're adjourned. Thank you.